Assalamualaikum warahmatullahi wabarakatuh. My name is Naira Puspita with the last three digits of my name are 316. On this occasion, I'll be explaining about the country who has strong historical connection with our beloved nation. Could you have a guess which country is it? Exactly. If you're thinking it's Netherlands, then you're right. Netherlands is the country who has colonized Indonesia on the past and brings so much impact to our people's life. But I'm not going to talk about this. Instead, I will give a quick introduction about the Netherlands. So the Netherlands is known as Kingdom of Netherlands. This kingdom is located in Western Europe. For the capital city is located in Amsterdam, which serves as the country's cultural and economic hub. But for the government is located in Den Haag, which serves as political and administrative center of the country. The country follows a monarchical system of government, where the king or queen as the head of the state. Meanwhile, the government is run by the prime ministers. After knowing a bit about the country, I will provide an explanation about the legal system in Netherlands, but only in general terms. So make sure you are listening to the explanation.
Now we are going to talk about Netherlands legal system. So the Netherlands legal system is based on the principles of individualizations and liberalizations, which are characteristic of continental European law or known as civil law system in general. For its own development, the Dutch legal system has been heavily influenced by French law, leading Reign David to classify the Netherlands as part of Romano-Germanic legal family. And in the late 19th and early 20th century, several civil law countries granted judges or courts the authority to create general principles of civil law when written civil law was unavailable for application in specific cases. The authority of judges to exercise discretion in deciding civil cases also exists in the Netherlands, even though the Netherlands has been gradually codifying its civil law from 1947 to 1992. The courts in the Netherlands have the authority to interpret the law and render decisions based on existing principles. Although written law exists, judges in the Netherlands also have the freedom to apply discretion in certain cases, especially when the written law doesn't cover the situations they face at that time. And for the primary lawmaking body is formed by the parliament and collaboration with the government. When these two institutions work together to create law, they are referred to as legislatures. The power to create new laws also can be delegated to local governments or certain organs of state, but it's only for specified purpose.
Now we already have a brief overview about the legal system in Netherlands, and I'll be moving on to our main topic discussion regarding one of the branches law access in Netherlands. So I will give an explanation about the commercial laws and its various types. Without any further ado, let's get into the topic.
What is commercial law? So, commercial law is a set of legal rules governing all commercial and business activities occurring in the country. It encompasses everything from the formation of companies, buying and selling transactions, business contracts, to consumer protections. If we want to know the roots of Dutch commercial law, it can be traced back to the French Code de commerce, which was established in 1807 and adapted into the Wetbook Van Coop Handel. And next, we will talk about the main branches of commercial law on Netherlands. The first one, there is General Commercial Law, or known as Algemeen Handelsrecht. It's divided into four parts. The first one is contract law, which governs all matters related to agreements in commerce, such as sales, leases, agency, and others. There is company law, which regulates the formation, management, and dissolution of various types of business entities, such as public limited companies, private limited companies, and cooperatives. And there is security laws, which governs financial instruments such as shares, bonds, and promissory notes. And last is bankruptcy law, regulates the procedures for the bankruptcy of a company. And the second branch is called special commercial law. It consists with 5 parts. There is maritime law, which governs shipping, marine insurance, and other maritime legal matters. And there is insurance law, which regulates insurance contracts, types of insurance, and insurance claims. And there is transportation law, which governs the transportation of goods and passengers via land, sea, and air. There is banking law, which regulates banking activities, banking products, and banking supervision. And last, there is a thing called intellectual property law, which governs the protection of intellectual property rights, such as copyrights, trademarks, and patents. And the last branch is international commercial law. Consists with general international trade law, which govern cross-border trade transactions such as international sales, Incoterms, and international dispute resolution. And last, there is foreign investment law. Regulates direct and portfolio foreign investment in the Netherlands. Now we are already in the end of today's discussions, but before I end this discussion, I will convey the following quote from J. William Fulbright. He said that law is the essential foundation of stability and order both within societies and in international relations. Okay, so that's all for me. I hope from bringing this topic, it will increase both of our knowledge. I would say thank you for your time and your attention. Wassalamualaikum warahmatullahi wabarakatuh.